Hi everyone, and welcome for joining us today. I'm just going to wait a few minutes while we have everyone joining in. I can see some people entering now. Welcome. You should be able to see on your screen a presentation that says Hunt and Hunt webinar recovering from COVID post lockdown. If you are not seeing that, then just pop a message in the chat and we'll see if we can address that and try and help out what's going wrong with the presentation. But we'll begin in just a quick moment while we wait for everybody to join in. Okay, we'll get started. So thank you for joining us here today for the Hunt and Hunt Business Support webinar series, where we'll be talking about how businesses can recover post-lockdown. I'd like to begin today by acknowledging the Gadigal people of the Eora Nation, the traditional custodians of the land on which I am today, and I pay my respects to their elders past and present. I extend that respect to Aboriginal and Torres Strait Islander people here today. Just a quick few housekeeping before we get into the presentation. Please use the Q&A function, which you should see in your control panel to ask any questions. We will not be monitoring the chat, or really we won't be monitoring the chat to answer any questions. We really only will be answering the ones which are in the Q&A session. We have a few hundred people who are here today, so we'll only be looking to that Q&A session. We have the wonderful Joey Tass, who's in my team. He'll be answering as many questions as he can directly, and we'll also be picking a few questions at the end to be talking about live. The presentation slides will be sent after this presentation finishes, as will a copy of this recording. We have a lot of content to cover, so we will be finishing on the hour. But if we do have any time afterwards, then we'll be answering any questions, but we'll make sure we address the content in the hour, and then anybody that needs to leave can, but we will record all of the questions that extend beyond that hour, and you can watch it later on once you get a copy of that recording. So, moving to the first slide. So I'm Sarah Capello, and I'm a partner here at Hunt and Hunt in our litigation and workplace relations team. I'm joined today by my wonderful colleagues, Matt Gauci, who's our insolvency litigation partner. Hey, Matt.
Hi, Sarah. Hi, everybody.
We also have Jess Baldwin, who's a senior associate in the environment and planning team. Hey, Jess.
Hi, Sarah. Welcome, everybody.
And Nicholas Sharman, who's a senior associate at property and commercial team. Can you hear me, Nick?
Yes, thanks, Sarah. Good afternoon, everyone.
Wonderful. We also have Joey Tass, who's on mute, and he's a senior associate in my team. He'll be answering the questions, as I mentioned. I'm also very excited to welcome our special guest, Leanne Hegarty, partner of KPMG. Leanne is an accountant of over 20 years and works with family businesses, fast-growing companies, and high net worth individuals. Leanne will be providing a financial lens on the discussion today. So thanks so much for coming today, Leanne. Oh, so Leanne, you're just on mute, sorry. Sorry, Leanne, we'll just, Leanne, you're on mute there, so anyway.
Yeah. Thank you, Sarah, and hi to everybody, and I do apologise for that to get going.
Oh, it's okay. We're all well and truly used to it by now with you're on mute. But thanks so much, Leanne. We look forward to your financial contribution and guidance. So our agenda for today is really a follow-on from our last webinar, which was held on the 25th of September, where we discussed the COVID vaccinations in the workplace. But because it was a national audience, our aim was to be more generalised. But today we're going to be very specific in talking about businesses and individuals in New South Wales. So Jess is going to be providing a thorough outline of the current public health orders. I will be talking about how they are applied in the workplace. Nick will then be addressing property, including commercial and retail leases. And Matt will be providing a toolkit for reducing debt and increasing cash flow. And Leanne's going to be providing the financial lens throughout the entirety of the presentation. So our intention is to really be a resource for you and your business and help you transition out of the lockdown restrictions. The rules are changing constantly, sometimes daily. So we will also be identifying where you can go to access current information, although of course we are also here as a resource if and when you need. So I'll hand over to Jess now, who's going to be talking about public orders.
Thanks, Sarah. So the public health orders in New South Wales are created under the Public Health Act. So this is where the Minister considers that there's a risk to public health they can bring in a public health order, which is meant to be implemented quickly. So it's not like writing a new piece of legislation where it goes through Parliament. This is things that are done on the fly, on the run. So they're implemented very quickly, which means that sometimes they can't capture every single circumstance. We get some of these grey areas, and they can be quite hard to comprehend what's happening, especially because they keep being changed every few days. So it's an offence under Section 10 of the Public Health Act not to comply with a public health order, and you can be issued with a fine or even imprisonment for individuals, and companies can also be issued with fines. And there's also ongoing offence provisions. So if you are not meeting the obligations of the public health order, you can be issued with an ongoing fine. Currently there are a number of public health orders. The first one that I'm mostly going to concentrate on today is the General Public Health Order. And this applies now generally across New South Wales. There are provisions within this public health order that would apply to a hotspot area if required, but at the moment, thankfully, we don't have any hotspots in New South Wales. So we're just looking at what applies in the general area. There's also a public health order in relation to self-isolation, and Sarah will touch on that more as well because it relates to health workplaces. And then we've got mandatory vaccines through some of the public health orders for education, care workers and healthcare workers. Sarah's also going to touch on that. And then there's the quarantine requirements for air and maritime transport. So where do we find the public health orders? So a lot of the time we're relying on New South Wales Health website, or you may have been listening to the 11 o'clock presses when they were a thing to get your information. But it's important that you check the New South Wales legislation website where the public health orders get uploaded. So thankfully, when you go to the homepage of New South Wales legislation, we've got this notice board where we can click on this COVID-19 legislation, which is highlighted there in purple. So when you click through to that, you'll be taken to a page that looks like this, which has a list of all the public health orders that are currently in at the moment. So the first one there is a general one. So you can see that just looking at, it's been amended, twice on the 21st of October, once on the 20th, the 19th, the 18th. So it's changing every day at the moment. So make sure that you get the most up-to-date one. And you can also see on the right-hand side there, they show the amendments. So if you want to find out what's just changed overnight, you can click on that amendments one and it will give you a brief summary. So I've been looking at the one from 2:12 p.m. on the 21st of October. So what you really need to look at is about the purpose of what you're undertaking on your premises. So I've been helping Sarah and her team a bit with this because the public health order really looks at your land use and relies on the definitions that we find in the Standard Instrument Local Environmental Plan, which is the area of law that I usually look at. So whether you're a retail premise or a business premises, a nightclub or office premises, means that different rules will apply to you. So you might want to consider about what your approved use is at your premises. In terms of working from home at the moment, the general rule is really if you've been vaccinated, an employee must still allow you to work from home where it's reasonably practical. But if you haven't been vaccinated, an employee must require an employee to work from home unless it's not reasonably practicable. But we'll also have a look at specific industries as well. So an unvaccinated worker cannot attend a workplace if the workplace is one of these types of work or purposes. So a hospitality venue, an entertainment facility such as like a cinema, hair and beauty. We've got all the gyms, health studios, things like that, libraries, museums, auction houses, markets, these types of things. So next slide. So I'm just going to focus on three main areas that you may be interested in. So retail, hospitality and office premises. So at the moment, some of the general rules that apply to these types of businesses are indoors. We've got the 1 4 square metre rule applies. In hospitality, we've got outdoor 1 to 2 square metres. We've got face masks, For retail, it's still click and collect only for unvaccinated individuals. And in retail generally, that's not critical retail, so not supermarkets, but other retail, you must take reasonable steps to ensure an unvaccinated adult is not on the premises. So some of the things that you might want to consider are having a poster or training your staff to check vaccination statuses and exemptions, and just reminding customers maybe when you're taking a booking. And that also applies to hospitality as well. So hospitality at the moment, no bookings of more than 20 people unless it's for a significant event, which is a wedding or a funeral. And operator really needs to ensure that all their staff are wearing masks when they're dealing with a member of the public. They're considered a higher risk venue, so we can't have people under 16 that aren't vaccinated unless they're a member of staff or they're with a vaccinated member of their household. And in office premises at the moment, where face masks are no longer required if you're vaccinated, but only when you're in the office space. So it's not if you're like in a cafe or something that might be in the lobby of an office building. So COVID safety plans, an occupier of a premises that's listed in Schedule 4 must develop a COVID safety plan. So when you go to Schedule 4 of the General Public Health Law, there's about 40 different premises types or business types that you might want to see if you fit within one, and it tells you what type of COVID safety plan you must have in place. And also responsible people for certain events must also have a COVID safety plan in place. So that includes things like religious services and also open houses for real estate agents. And you might want to note that there's going to be still more upcoming changes. From 1st of November, it looks like hospitality bookings will no longer be capped at 20 people, and the regional exemptions for partially vaccinated people will also be removed. So the same rules will apply across the whole state. From 1st of December, we don't yet know what this looks like, but it has been flagged that lockdown rules will end for unvaccinated individuals. We don't know whether they'll need to require proof of a test or something like that, but so we need to watch that space when we get to 1st of December. And the expectation about working from home, it will be now probably at the discretion of the employer. So employers really need to then be able to manage the risk of COVID within the workplace, which Sarah is going to talk about more in a moment. But maybe, so what businesses really need to consider is that the public health order is that bare minimum. It's what you need to do to avoid a fine, but that may not necessarily meet your WHS requirements to provide a safe work environment. So some other things that you might want to consider when providing a safe work environment is making sure that you're using open and well ventilated spaces and that your air conditioning systems are well maintained. You may also want to consider getting a ventilation engineer or occupation hygienist to do an audit of your space and your ventilation facilities. So we don't really know what the future holds in this area, or whether there's going to be some type of ventilation or COVID design guidelines, but it'll be interesting to see what happens next. So I'll hand over to Sarah now.
And then, before we go to Sarah, I'll throw in there, and that's particularly one thing we talk about in this is in relation to risk. And when we talk about risk, we think one of the things in relation to managing that risk is insurance. And particularly around the retail, hospitality, general public, and those sorts of things. And what we're seeing at the moment is it is across the board in relation to businesses, is this coverage uncertainty. So when COVID first hit, businesses were shut down, and the immediate response was, oh, that's fine, it's okay, I'm covered by my business interruption insurance. Well, not quite. What we have seen is that a number of businesses have had cover when they've had things like events cancelled, but just in terms of, I've had, because of the health orders, it shut everything down, that should be considered business interruption, I have a loss of profits claim. Not at all, not at all. So insurance policy, and it really depends on your insurance policies. Look, I'm not a lawyer, and again, this absolutely goes to getting advice from the likes of Hunt and Hunt in relation to exactly what's included in there. But there's been two cases, I believe, so far. And in the first case where it was actually found for the insured, that the courts did rule for the insured and said, yes, they were covered. The insurers weren't happy with that, so they've recently put another case forward, and the result in that was it depends. And so what's really, I suppose, where I'm getting to in this is, don't just think, oh, look, it's all this big pandemic, they're never going to do anything. You actually may have a policy that will cover you for some of this business interruption insurance, but it is very, very specific, and you may have some specific inclusions in there. So what's to sort of think about now with this is, maybe you could be covered. So I would absolutely be having a look at whether you are covered or not, and whether you can put a claim in. Last statistics that we looked at, I think it was only about something like about 1% of people that are potentially entitled who have actually made a claim. So have a think about that. But the big piece is the going forward. And what we've absolutely seen with people coming up for their renewals, how more explicitly the exclusion clauses are being included for things like a pandemic. So it's really important, number one, to be thinking about what risks you are covered for, particularly around that business interruption. Are you covered for anything during this last period of time? But also, don't just accept what you were given in your current renewals. You may need to shop the market a bit, because you may be able to find that you can get some sort of cover and or just a little bit more widening of what's defined within your policy to give you some greater risk cover moving forward. Thanks, Sarah.
Thanks, Leanne. It's a really helpful tool, and I guess that's what we're trying to focus on here today, is to try to give everybody some resources just to explore what's out there in order to help businesses recover as we get out of lockdown. Thanks for that, Leanne. So now I'm moving on to work health and safety and employment. Now, as Jess mentioned, where there's a public health order in place, you really must comply, otherwise you'll be in breach of the law. And as Jess outlined, the public health orders cover a number of matters relevant to the workplace, including vaccinations, work from home requirements, face coverage, and really we need to be looking to that first to see what rules is going to have that will govern the workplace. So in my section, I will be setting out very clearly what to do in order to comply with those orders, and also to comply with the Fair Work Act and your work health and safety obligations. So in our last webinar, and also through a number of general inquiries that we've had received to date, we've got a lot of questions about any challenges to the public health orders, and often people say that they're unconstitutional. But to date, there's been a number of proceedings filed in the New South Wales courts challenging the validity, but as at today, I'm not aware of any of those having been successful. So as it currently stands, the public health orders are what we look to see how it's going to govern our workplaces. So there's some significant penalties that can be attracted if there's a breach of the public health orders. And it is a criminal offence if they're not complied with. So for an individual, the maximum penalty is $11,000 or imprisonment for 6 months, or both. For a corporation, it's up to $55,000, and a further $27,500 penalty may apply for each day the offence continues. So I expect fines in this order will be pretty devastating for businesses who are already suffering from the lockdown period. But I'm sure that's not going to happen to anyone here, because you're taking the right step and you're getting information and doing all the right things. So what happens if an employee refuses to comply with a public health order? So if we take, for an example, the public order that requires employees in specific industries to be vaccinated, such as the healthcare, education, or aged care sector, the employees may be aware that it is mandatory to be vaccinated. However, they are still refusing. So what are you to do? First, and I say this in most cases where I'm advising clients, is before you start a formal process, talk to your employee. Get information about why they're refusing, and the situation we're all going through is really unprecedented and stressful. So just having that one-on-one conversation and giving them encouragement to get medical advice to help them make the decision might be all you need to allay their concerns, and it might really resolve the problems. But if the employee won't chat, or if they've indicated their intention not to comply with the public health orders, then you need to embark upon the formal process, which I've set out here in this slide. As I said earlier, where there is a public health order in place requiring employees to be vaccinated, employees would be in breach of the law if they allowed employees without a valid exemption to continue working or even to enter the premises. So Jess spoke about there earlier some premises where unvaccinated people can't attend. So if they can't attend the premises, do not immediately stand them down. So this seems to be the response from many employers, and it sometimes does not go very well. The standing down of an employee under the Fair Work Act is only available in the most limited of circumstances, such as a stoppage of work or where the employer is not responsible. As employees, refusing to be vaccinated will almost certainly not fall in this category. That doesn't mean that you have to keep paying them. They may not be able to perform their duties, and therefore it is possible that you could explore suspending them without pay. But to do that, you first have to look to the applicable award or the employment agreement to see if that's permitted to do under that instrument. If suspension is not available or not the preferred option, speak to the employee about them taking either paid or unpaid leave. But this must be by an agreement. You cannot force an employee to take leave unless there's specific circumstances, such as Christmas. You know, if when you close over Christmas, you can give notice and require them to take leave then, but this is not the case here. If the employee can work from home, this option should be explored first. However, for most of the industries that have the mandated vaccination through a public health order, this will not really be possible. So if suspension or taking leave is not applicable, you may have to consider termination. So it's really important to follow a process. First, invite the employee to a formal meeting to discuss the public health order and how it will apply. Make sure to follow that, to offer that they bring a support person and have the meeting face-to-face. Now, face-to-face, you can't do it in actual person, but do it by video conference. So they can't come to the premises, but you still need to have that same personal connection. In the meeting, talk about the reasons as to why they're not complying. They may have a medical reason, and they may have just not got the paperwork in order or realise that they have to provide a medical contraindication form. Also discuss with them what it means for them if they continue to refuse to comply, and that is that it'll mean termination. So take notes of the meeting. During or after the meeting, issue them with a written direction clearly outlining what they need to do and by when. In the vaccination example, you would say that they must show proof of vaccination or a valid medical exemption by a specific date. If they still do not comply by the date, invite them again to a formal meeting and inform them of the decision to terminate. During or immediately after the meeting, give them a letter of termination outlining those reasons. The reason in this case is a failure to comply with the public health order, a failure to follow the lawful and reasonable direction, and an inability to perform the inherent requirements of the role. Now, this is the best practice that we recommend that you take in order to make sure that the dismissal is not deemed harsh or unjust. But in this case, there is a valid reason. So you tick that box, but the process is also very important. Now, this is the clear path to follow if a public order applies. But what if it doesn't? And for many businesses and many people who are attending here, they really are operating outside of the public health orders. And by that, I mean, there's not a clear order that dictates whether an employee should or shouldn't be vaccinated. So in those cases, the business then needs to make a decision about whether they want what they want to do and perhaps implement a policy or about requiring vaccinations. Now, I'm not going to discuss in any detail the legality of mandating vaccinations in the workplace, as this was covered at length in our last webinar. So I've got here the link to the recording and an outline of what we discussed. So I invite you to go ahead and watch that if you in two minds about what you should be doing. Now, if you did attend our last webinar, you'll know that we discussed at length the work health and safety obligations, as well as the reasonableness of a direction. So an employer has a duty to eliminate or reduce harm so far as reasonably practicable. Now, this is an incredibly important factor because it is not just an employer entity that can be liable for breaches, but under the Work Health and Safety Act, an individual may also be prosecuted and face heavy fines and penalties. So if you're a director of a company and you don't meet your work health and safety obligations, you can personally be fined and end up in prison for failing to comply. So in light of this duty, employers are expected to implement control measures. We addressed this in our earlier webinar, but as a reminder, these control measures are listed here in the slide. But looking specifically to the vaccinations, you can see that this is the first control measure identified as an effective way to reduce or minimise harm. Whether this will be reasonable or not, you need to look to the specific workplace and the environment and consider items such as the location of the workplace. Is it in Greater Sydney or is it regional? What is the status of the outbreak in that location? Is the role customer facing? Can everybody maintain necessary distance? Or what is the effectiveness of the other control measures? Now, to give a recent example, you may have heard that last Thursday, Woolworths announced that they would be requiring all employees across the nation to be vaccinated by either January 31 or March 31, depending upon the state they're in. In their case, they report to have an average of 20,000 customers a week. So their staff are exposed to a significant risk each time they turn up for a shift. So the Woolworths employees cannot work from home, and other control measures are likely to be insufficient to protect them. So in that case, it seems very reasonable that they are implementing a mandatory vaccination policy. As against that, if the employee works from home, if they're not customer facing, if they can socially distance from others, if they're willing to wear a mask or submit to testing frequently, then it's not so clear as to whether it would be reasonable to fire them if they do not agree to get the jab. So how do you go about mandating the vaccination if you decide that your business, it would be appropriate for you to do so? So there are two ways. You can do either or both. I recommend both as best practice. So you can go about create a policy, or you can issue a lawful and a reasonable direction. In most instances, you must consult with your employees before implementing a policy. We recommend that the policy is in writing, and we can help you with that. The policy should be uniformly applied throughout the workplace, but also flexible enough to take into account individual circumstances. It should be clearly written so that it can be understood and uniformly implemented. To date, there has been 3 unfair dismissal applications that relate to mandatory vaccinations that have been decided in the Fair Work Commission. The cases relate to the mandating of the flu vaccination, however, and not COVID, but it does provide some insight into what the courts are going to do. In each case, the mandatory policy was found to be a lawful and reasonable direction, and the employees were found to not have been unfairly dismissed by refusing to be vaccinated. As an alternative, if for some reason they don't want to have a written policy, an employer can still issue a lawful and a reasonable direction in writing, but employees are required to comply. Otherwise, if they do not comply, then they'll be dismissed. So the direction is lawful if it's consistent with an employment contract, applicable award or instrument that governs the employment relationship. And it is most likely that direction requiring vaccination will be lawful. But the reasonableness of the direction, however, is not clear, and it will really depend upon the particular circumstances, which are assessed on a case-by-case basis. It is different for each industry, for each employer, and also it can actually vary within the workplace. So for one employee, it might be reasonable, but for another in the same workplace, it might not be. So when considering the reasonableness, go back to those same factors that I discussed earlier, such as what are your obligations? Can you comply with them? Can you implement the control measures for each individual employee? If the answer is no, can the employee perform other duties? Can they work from home? Can they be kept separate? So what can you do to put those measures in place? If you're a small customer-facing business with a few employees who work in a small premises, it is likely that the direction is going to be reasonable. But if you're a larger corporation with many different positions available, some of which can be performed from home, it may not be so reasonable. But if you do decide to issue the direction, it should be in writing, be very clear on what to do and by when, and also include the reasons for the direction. Now, what to do if your employee refuses to comply with a policy or a reasonable direction. This slide looks very similar, and it is because it's a cut and paste of my earlier slide, because the process is essentially the same. So I must emphasize, though, the importance of getting advice before you actually take the steps of termination. But if you do wish to proceed down that path, then and you've got the advice, then follow this process. It's really important to make sure that you've got the steps outlined and you give the employee an opportunity to know what the consequences of their refusal are going to be. So there's been no case yet that I'm aware of in the Fair Work Commission dealing specifically with refusal to receive the COVID vaccination, but it is likely to be a valid reason for dismissal, but the process will dictate whether it's going to be harsh or unjust. So moving next to then getting employees back into the office. So we're talking about bouncing back, and many people want to get back into the office. So some, like me, are really excited to be back. It's my first day in the office today after a few months, so I'm really stoked to be here. But others aren't so happy about it, and they want to work from home. But like mandating vaccinations, you first have to look at the public health orders. And as Jess spoke about earlier, the employer must allow vaccinated employees to work from home if reasonably practicable to do so. And unvaccinated workers are required to work from home unless not reasonably practicable to do so. So we've given a few clients advice about this over the past month, about who can and cannot be on the premises. And in some instances, unvaccinated persons cannot be on the premises, and therefore in those cases they can't be there. So as I said, I follow the process that I outlined above. If they can't be on the premises and go through all of those steps, don't stand them down and ask them to take leave or suspend them if that's an option, or consider termination if that's where it comes down to. So the work health and safety obligations are always paramount. This is the duty to eliminate or minimise risks so far as reasonably practicable. So don't get your employees back in the office unless it's safe to do so. So this is a case that I spoke about in the last webinar, but really what it came down to was the employee, Benjamin Yu. He didn't want to come back into the office because he was concerned about the outbreak. He refused to come back in. He was ultimately dismissed. They found that the dismissal was a valid reason for dismissing him, his refusal to come into the office. But ultimately the decision was that it was unfair because they sacked him by telephone. So that's why you have to have that face-to-face meeting. So looking about what to do if your employee gets COVID. So this unfortunately might become a common occurrence once the state opens up, and the rules are very clear. From 21 October, if the employee contracts COVID in the workplace, then the employer must notify Safe Work within 24 hours. They must also inform New South Wales Health if there are any close contacts, and they have to send an email to the address that I've listed there. So a workplace doesn't include a worker's home, even if they are working from home. So there's no obligation if one of your employees is working from home and they're COVID positive. So unless they're coming into the actual workplace, then you don't have to follow these reporting requirements. But that's not to say that there aren't any work health and safety obligations. So these are the bare minimum requirements. But if you do have an employee who gets COVID in the workplace, then we recommend that you take a number of steps to make sure that you're implementing those control measures and you're reducing the risk of harm to the balance of the employees. Keep in mind there's also privacy obligations here, so make sure you're not disclosing any sensitive information about any infected workers without their consent, and you also should maintain confidentiality of anybody else who's a close contact. So on the last slide, I've set out here what the obligations of the employee is, and that is obviously they must notify the employer if they get a positive result. And I've outlined also the self-isolation obligations. The rules have just recently changed. It was formerly 14 days. Now it's 7 days for fully vaccinated persons, and then it's still 14 days from an unvaccinated person. So I'll be moving over to Nick, who's going to be talking about property, so commercial leases and retail leases. And then if there's any questions, then shoot them through the Q&A.
But before we jump into Nick.
Oh, sorry, Leanne.
That's quite okay. No. Well, with everything, the thing is, with everything that Sarah has been saying, on the one hand, it's quite, in quotes, operational, but it actually absolutely comes under the heading of governance. And so, you know, there's that, it's like, I don't have time to work on the business because I'm in the business. And a lot of this stuff seems like it is very much in the business. But as Sarah said right up front, as a director, as an owner, you absolutely have the responsibility for this. And you can't just rely on, yes, you've given instructions to Bill, Mary, Bob, whomever, and oh, it's their job. No, it's their job to implement your instructions. You as the owner / director, it is your responsibility under the governance of your business. And why I absolutely want to sort of, I suppose, put this one up in highlight is that this governance piece is becoming an increasingly target area for so many compliance organisations. So the ATO will undertake now, they're doing governance reviews. So it might be all well and good, is this tax deductible or not tax deductible? They're concerned with your governance. Is your governance right? ASIC are doing governance reviews. And what we've actually also found now is financiers, particularly during COVID, are looking at the governance of the organisation. Are they thinking about the things that they should be thinking about? Are the directors aware of their responsibilities of what they should be doing? And are we satisfied that their governance and the decisions and their policy-making procedures are appropriate? Therefore, if we can get comfort around that, that's giving us greater comfort around us lending the money. And as business owners, we all need finance. And so I can't stress enough that governance and good governance practices are really, really important. And, you know, write down, yes, it's the OH&F stuff. It might even be the dividend policies. So it's all well and good. Again, we put all these plans in place to say, well, our policy is to pay distributions here or distributions there, dividends at this time. But then suddenly the government comes and says, oh, sorry, you've got to shut your doors on Monday. Well, what does that mean? Do we still pay it or don't we pay it? What does that mean to the stakeholders who have made commitments based on them thinking they're going to get various different distributions? And as we're getting, I mean, and Matt will talk later in terms of cash flow, should we be paying out distributions when we don't know what's happening tomorrow? Difficult one. But as part, again, like, you know, as we said, you've got to look at what you're doing with your insurance. And I know it's really hard at the moment because everybody's really thinking about, oh my gosh, what's tomorrow going to bring? But we have to really start to also think about the next week and the next year. What does it mean for our business model? How resilient are we going to be? Can we continue with our business model based on what we don't know now? What does that mean? So really going through, particularly what Sarah said, that's one element of, put that under the banner of governance and think, and don't just put it on the to-do list. Speak to Hunt & Hunt, speak to your advisors. Now's a perfect time to review your governance. You know, as I say, it's the tax man, it's ASIC, it's your financiers, it's your insurers. You've got to get this stuff. Your house has got to be tidy in this, and don't rely on your employees to implement it because it's your responsibility. Thanks, Sarah.
Thanks, Leanne. That's, again, really sound advice. And as you touched upon, speak to your advisors. You know, we're here to help guide you through this process. So Nick, moving over to you to talk about property.
Thanks, Sarah. As both Jess and Sarah have touched on, there's a seeming ever constant stream of government directives through these public health orders that are providing an additional layer of complexity to an already challenging exercise of readying businesses for trading. The obligations that are imposed on occupiers of certain premises are no different. The general public health order puts the onus on occupiers of particular properties to essentially enforce elements of the public health order by developing a COVID safety plan, ensuring that that plan is complied with, taking reasonable steps to ensure that a person checks in to the premises, and taking reasonable steps to ensure that unvaccinated adults are not present at, for example, high-risk premises, hair and beauty salons and the like, non-critical retail premises, auction houses, and so on. Jess had previously provided us with a comprehensive list of some of those premises, and so too some commentary on the taking of reasonable steps in terms of occupiers having to comply with the public health orders. Not only, however, must businesses be compliant with the public health orders, they've also got to be across the retail and other commercial leases COVID-19 regulation, which I will refer to as the regulation. As businesses start reopening under the public health orders and begin to increase their turnover, it's going to be worthwhile for us to hone in on some of the key considerations for both landlords and tenants in navigating their current leasing arrangements, which will continue to be governed by the regulation. In doing so, I'll also briefly touch on what those arrangements might look like when the regulation is repealed on the 13th of January of next year. So first of all, the regulation applies to retail shop leases and certain commercial leases entered into between, or rather before 26 June of 2021. The overarching objective of the regulation is twofold. First, it aims to limit landlords' liabilities to exercise certain rights under retail and certain commercial leases for a breach of lease if the tenant qualifies for certain grants due to the impact of COVID-19, otherwise known as an impacted lessee, and the breach of the lease is a prescribed breach that occurs during the prescribed period. Additionally, the regulation also directs leasing parties to the negotiation table and encourages the renegotiation of rent and other terms of the lease having regard to the code of conduct. From this, there are a series of questions that both landlords and tenants ought to be asking themselves in considering the application of the regulation and to what extent, if at all, it modifies their existing obligations under their leases. First of these questions, which we've got on the slide there, is the tenant an impacted lessee for the purposes of the regulation? An impacted lessee is one which qualifies for one or more of the following grants, being the Micro Business Support Grant, the COVID-19 Business Grant, or the JobSaver Grant, and its annual turnover for the 2020 to 2021 financial year does not exceed $50 million. It is incumbent on tenants to produce evidence which demonstrates that they are an impacted lessee for the purposes of the regulation. Tenants must be giving this information to landlords either as soon as practicable after a prescribed breach occurs, and also within a reasonable period of time after it has been requested by the landlord. Importantly, landlords may rather request this information at any time to ensure that a tenant remains an impacted lessee, but it cannot request the information more than once every 2 weeks. The categorisation of a tenant as an impacted lessee is going to give rise to certain implications. Most notably, the rent must not be increased during the prescribed period, and landlords cannot take prescribed action for a prescribed breach during the prescribed period unless the parties have tried and failed to renegotiate the rent or other terms of the lease, and the matter has been referred for mediation and the registrar has certified in writing that it has failed to resolve the dispute. Now, let's unpack some of these defined terms that I've got in quotation marks. First of all, a prescribed breach, a prescribed period is between 13 July 2021 to 13 January 2022. Next is the concept of a prescribed breach. Among other things, the regulation defines prescribed breaches to include the failure to pay rent, failure to pay outgoings, or the failure to keep the business open during the hours specified in the lease. Importantly, the regulation does not preclude landlords from taking prescribed action on grounds which are not related to economic impacts of the pandemic. For example, this might include the tenant's breach of the covenant not to assign the lease or sublet part or all of the premises without the landlord's prior written consent. So, if we've identified that the tenant is an impacted lessee and a prescribed breach has occurred during the prescribed period, you might be asking, what now? Well, landlords are then precluded from taking what's known as prescribed action. The regulation identifies such actions as, for example, evicting their tenant from the premises, seeking damage, requiring the payment of interest on unpaid rent, recovering a security bond, or terminating the lease. It is important to note that the regulation has not been understood by the courts as temporarily pausing landlords' rights to take prescribed action until the expiry of the prescribed period. In the matter of Sneaker Boy, which I've got up on the slide there, Justice Robb, in considering the 2020 regulation and this particular issue, expressed the view that such breaches which occurred during the prescribed period could not be actioned by landlords either during or after the prescribed period. Again, it is important to remember, however, that before landlords can take prescribed action, there are two things the parties need to have done. The first of these is to try to renegotiate the rent, and the second is to go to mediation. Dealing first with the obligation to renegotiate. A party to an impacted lease may request the other parties renegotiate the rent and other terms of the lease. A request to renegotiate must be made in writing. It must be commenced within 14 days of receipt of that request, conducted in good faith, and it must have regard to the very liberal requirements of the code, the economic impacts of COVID-19. Any grants or payments received by the tenant are also to be treated as part of the trade or turnover of the tenant for the purposes of those negotiations. In practice, we've assisted both our landlord and tenant clients in drafting up documentation to formalise arrangements between parties to impacted leases. In many cases, we've seen the implementation of straightforward waivers or combinations of waivers and deferrals. In addition, the rent relief afforded to tenants is often agreed to operate for the entirety of the prescribed period. However, in some instances, this has been longer. In other instances, together with our clients, we've implemented some more creative and complicated commercial arrangements involving the unlocking of cash tied up in bank guarantees in exchange for insurance bonds, combined with, say, 50-50 waiver deferrals with deferred components attracting interest. And in this regard, it's important to keep in mind that the regulation does permit parties to come to their own commercial arrangements. On the one hand, the code of conduct, which I'm sure that quite a few of you would be familiar with, might not necessarily be seen as especially helpful to parties, given that it doesn't give us a great amount of very clear and precise direction on what good faith negotiations to leases might look like. However, on the other hand, it certainly has allowed parties the freedom to think outside the box and arrive at mutually satisfactory arrangements. Now, the second of the two items there that must be undertaken prior to taking prescribed action, the obligation to mediate. Of course, this is a rather straightforward one to, at least on paper, satisfy. Landlords must attempt with their tenants to mediate, and it's only upon obtaining a certificate from the registrar which certifies that mediation has failed to resolve the dispute will landlords be able to take prescribed action. As you might appreciate, this is certainly an arduous road for leasing parties to traverse, should in particular the landlord wish to take prescribed action. Now, just thinking ahead to the leasing arrangements after the 13th of January of next year, importantly, the regulation permits negotiations commenced but not concluded before 13 January 2022 to be continued and concluded after the expiry of the prescribed period. Of course, that's going to be of critical importance to parties whose negotiation of rent reductions has become rather protracted or focused perhaps on the analysing of turnover figures on a fortnightly basis. There are, of course, two major questions that will be on the minds of a lot of leasing parties as we roll on towards the 13th of January, and they are when will the rent return to normal, and can landlords increase the rent once the regulation is repealed? In typical lawyer fashion, I have to say that the answers to these questions will differ on a case-by-case basis. Excuse me. That said, the decision in the Sneaker Boy case does provide us with some insight into how the courts might interpret the current regulation in conjunction with the National Code of Conduct in respect of these questions. In paragraphs 73 and 74 of that case, which again, I do note that it dealt with the previous iteration of the regulation, Justice Robb observed, and you can see there that the effective part of leasing principle 3 that provides for a proportionate reduction in rent payable during the COVID-19 pandemic period and a subsequent reasonable recovery period has the effect that rental waivers and deferrals that are required to be negotiated could be not only in effect during the COVID-19 pandemic period, but in addition for a subsequent reasonable recovery period. We can see there further statement that the period of reduction is not tied to the period for which the pandemic affects the tenant's trade. So of course, this raises the question for us as to what constitutes a reasonable recovery period. And again, this is going to come down largely to the circumstances of each case. However, we can at least see from this decision in Sneaker Boy that courts, I don't think, will look favourably upon landlords who come 13 January immediately seek to enforce the rent and rent increases that are otherwise sanctioned under the lease, especially when their tenants are yet to return to their pre-COVID trading levels. Leanne, did you have anything further you'd like to add here?
One thing I was going to throw in on this one was, and we'll talk a little bit further as well with Matt, is one thing that we've been seeing that post getting advice in relation to one side from the landlord, the other side from the lessee's perspective, but more so from the landlord's perspective, is that, and I absolutely appreciate where they're coming from, is that, well, if I don't get the rent, I can't pay the bank. How do I do that? And look, and I've got to say, the banks have been all right in relation to, in some places, giving a little bit of a holiday as far as principal repayments are concerned. But as I say, they haven't abolished them by any stretch of the imagination, but they have been deferring some principal. But what has been of great assistance to a lot of people has been the, in quotes, the SMERLs. And when I say SMERL, I say it's the small to medium enterprise recovery loan schemes. So that's the loan scheme that's been offered where the government will guarantee 80% of the loan. So what a number of, well, not just landlords, but businesses have been accessing is this effectively sort of refinancing some of the loans that they've currently got under these new arrangements. And what it's been doing, it's enabled them to sort of get deferrals of those principal repayments, and in lots of situations actually reduce the interest rates on existing loans. You know, one of the greatest advantages around this is the loan rate is capped at 7%. And we've been doing some of them around as low as 2.5% for periods of up to around about 10 years. So in this situation, getting that advice in the first instance as to how to creatively be able to enter into negotiations from the landlord and the lessee's perspective, but then also thinking about that flow-on effect as to how can I make my commitments, whether I am a landlord or not, whether I'm a business owner, how can I make this work for me? And if you do have, you know, sort of restrictive financing arrangements at the moment, particularly while you come back to as to how you're managing that cash flow, really think about this loan recovery scheme. As I say, the new one was just announced on the 1st of October. Yeah, I think, yeah, it was the 1st of October, the latest one was announced. Banks have really got themselves organised in relation to this. You still have to go through the process of credit reviews and those sorts of things, but having that government guarantee of 80% for up to 10 years, yeah, look, I've got to say the banks are really open. It takes a lot of risk off their books by doing this, so they're definitely willing to have the conversation. So really think through having a look at that, maybe restructuring your principal on it, as well as also potentially getting some significantly more competitive interest rates as well. Thanks, Sarah.
Thanks, Leanne. So we're going to move over to a debt recovery section where Matt Gauci is going to be talking. So over to you, Matt.
Thanks, Sarah. And I share Leanne's sentiments. It's important to get your house in order. It's therefore important to look at ways to increase your cash flow, especially in circumstances if you've agreed to the rental relief of the type that Nick referred to, or just a business owner generally. One method to do this is to reduce your debtors. You may have sent reminder emails requesting payment of outstanding invoices, and you may not have been able to successfully negotiate payment from your debtors yourself. You might then be asking, what are your legal options to recover these debts that are owed to your business? And now there have been some changes brought on by the pandemic, and we'll quickly go through some options that we have found beneficial for our clients. The first option is a solicitor's letter of demand. This is a cheap, cost-effective solution. And although you may have already issued a letter or a statement directly to the debtor yourself demanding payment, we found that having a letter come from a solicitor can carry a bit more weight in terms of motivating the debtor to make payment of the debt. Moving over to the next slide. If your debt's owed by an individual, you may be able to commence proceedings in a court or tribunal to seek a judgment for the debt. Now, this is usually in the local or the district courts, but the appropriate court or tribunal will depend on where you live, the type and the value of the debt owing. Once you've obtained the judgment, then there are a number of options that are available to you to enforce that judgment. The first on the slide there is bankruptcy. Bankruptcy proceedings are usually initiated by issuing a bankruptcy notice. Once the bankruptcy notice has been served, then that gives the debtor 21 days to respond to the notice. If there's no response, then you can proceed to present a creditor's petition. This is where you file an application in the court and you ask the court to effectively make an order declaring the debtor a bankrupt. If the debtor becomes bankrupt, then a trustee in bankruptcy takes over that individual's finances and attempts to resolve that individual's outstanding debt. To go down this path, the debt that you're owed must be at least $10,000. In our experience, we have found that this has been a benefit to our clients, as once the trustee in bankruptcy has been appointed, then there's minimal involvement required from our client. This means that our client is no longer incurring further expenses and costs to essentially chase their debts. The next option is a garnishee order. This is where you obtain an order, usually from the court, in which you apply to seek the judgment for an order that money be automatically deducted from a debtor's bank account, from their wages or from their salary, or from a third party that you identify owes that debtor some money. The order requires the person served with that order to instead make payment to you for the amount of your debt. We've had a client recently who was owed money by a trade debtor. That debtor refused to pay the debt. We commenced proceedings and obtained a judgment in the local court, and subsequently obtained a garnishee order that monies be paid from that individual's bank account. We served the garnishee order on the Commonwealth Bank, and monies were paid into our trust account the following day to satisfy the client's debt. This was a great result for our client, and it was achieved in circumstances where the debtor did not wish to engage with our office at all, and we went through the process without any contact. The next option is a writ or writs of execution. So if you're aware that a debtor is the owner of either a house or some personal property, like some motor vehicles or an expensive TV, you can apply to the court for a writ, and that enables the sheriff to seize and sell the debtor's property in order to satisfy the debt. The benefit here to our clients is that the sheriff serves the writ on the debtor, and they attempt to negotiate payment from the debtor rather than our client. The sheriff is then responsible for seizing and selling that property, and if they're successful, then they make payment to us for our client and in satisfaction of that debt. There are sheriff fees that are payable, but these can usually be recovered from the sale of the property. Now, if your debt is owed by the company, then you can commence proceedings and you can obtain a judgment, but it's not always a necessary step that you have to take. There is the ability to serve the company with what's known as a statutory demand, and that's seeking payment of the debt so long as your debt is above the prescribed amount, and that's currently sitting at $4,000. There are quite strict technical requirements with statutory demands, and we highly recommend that you seek legal advice to ensure these are met. So similar to a bankruptcy notice, a statutory demand, when served on a debtor company, provides them with 21 days to respond. If no response has been received, then you can make an application to a court for an order winding up that company. That's also known as the court placing the company into liquidation. If the company is wound up, then a liquidator takes control of that company and seeks to resolve the company's outstanding debts before going on to close the company down. We find that issuing a statutory demand can be an effective tool for our clients, as often the company will be motivated to make payment to avoid being wound up. If they don't, and the company is wound up, then the directors lose control of their company. Moving on to the next slide. I've gone through some brief debt recovery options for you to increase your cash flow, but don't forget to have a look at your creditors and see whether you can make some impact there on your cash flow. Can you negotiate more favorable payment terms with your creditors? In our experience, the largest creditor of a business is usually the ATO. And late last year, Hunt & Hunt produced a webinar with our colleague, Charles Baven, and Charles has an extensive experience working with the ATO. Charles gave his top 5 tips, which are replicated here on the slide for dealing with the ATO. Have a look. We found in our experience these are quite beneficial to our clients. There's also a link on the slide here to that presentation on YouTube. And there's a link also to Charles's article on the Hunt & Hunt website, which he goes through these top 5 tips. Leanne, did you want to have any?
Yeah, look, I will
comments?
just throw in particularly on that ATO piece. It's not a lay down misere that you can get into a negotiate like a payment arrangement with the ATO. But having said that, they are very, very much open to the conversation because number one, they want to get paid, but number two, they are inundated with requests and they need to get them off their desk. Look, I mean, the traditional thing is, you know, you're scared of the ATO. No. Do not be scared. You're much better always being upfront and on the front foot with them and negotiating right up front that, look, I've got my BAS due next week. They can't do anything. Make sure all your lodgements must be there on time, but on the basis everything's lodged and you're calling them on day one instead of them calling you at day 100. They're very open to have those conversations. So I'd absolutely use them as a source of funding. Yes, it costs you. Yes, they charge you interest, but at the end of the term, you can then always go back to them and always ask for that interest to then be subsequently remitted. And I'd have to say 9.5 times out of 10, we generally get the interest back. So they can be a great source of funding for you. And also to that other point Matt said about the creditors, what we're also, like, a lot of times, and I've got to say particularly in professional services, and I know, like, we have it with our clients, we have an arrangement with another company that say we've got a client that owes us money. Well, what they do is they enter an arrangement with this third party and that third party pay us. So we get 100% of the fee, it all gets paid, and then you as the client then pay that third party. And you can arrange to have that over anywhere from, say, 3 to 12 months. And that, you know, again, there's a cost to it, but it's typically around 2 to 4%. So you're thinking, well, the supplier it doesn't damage any relationship with your supplier. You know, the rate's not that bad and it gives you that breathing area. So again, don't be scared about asking any of your suppliers for payment arrangements, or if they've got any arrangements with third parties to help pay. Don't be scared of the tax office. And at the end of the day, everybody just wants to get paid. And if you can get into some sort of regular arrangement, what we're seeing is, as I say, 9.5 times out of 10, everybody just comes to the table and works with each other. Thanks, Sarah.
Thanks, Leanne. So we'll wrap up because we've reached the hour, but we will, if you'd like to stay on for a little bit longer, you're welcome to. We'll answer some questions. But before we finish the formal part of the presentation, I just wanted to talk about quickly our upcoming webinar, which is on Wednesday, the 3rd of November. Jim Harrowell, who is a partner here at Hunt & Hunt with a lot of experience, will be talking about China and some of the challenges faced in the Australian Chinese market. So he's being joined by a number of experts in the area, and if you if you and your business have any interest in this, it's definitely one not to be missed. So there's a link there that you'll get when we send the presentation through. So that's the formal part finished. Any questions that there's a couple that have been sent through that I'll answer now live, but if you have any other questions, and all of our details are there on the screen. That's all of our email addresses. You can call the number there for Hunt & Hunt, and you can ask for any of us, or if you have a more general inquiry, we'll find the right person to answer the question for you. And then of course there's Leanne's details if you've got any of the accounting questions, and she can give you some more tools about how to get back and open and try and, you know, succeed. So that's what we're all trying to do, is succeed after this unprecedented times. So just some of the questions that have come through, they all seem to relate to employment, which is the most, I guess, the uniform topic. I'll just answer a couple of them. If any of the panelists want to jump in as well with some insight, then please feel free to do so. But one of the questions was, can we require any new employees to be fully vaccinated? The answer to that is generally yes, you can. You can make it a condition of employment for any new staff, and incorporate those terms into the written employment agreement. We have those terms already drafted, so we can help plug that into any existing employment agreements if you'd like some wording around that as well. Again, though, it'll come down to the specifics of the workplace, so you need to get advice about whether it's the right thing to do. It's typically not discriminatory to not hire someone because they're refusing to be vaccinated. It is discriminatory to not hire somebody because of an illness or a medical disability. So if they have a medical reason they're not being vaccinated, then it does potentially fall in that discrimination space. So get the right advice. And just keeping in mind, as I understand it, the person's vaccinated status actually includes people who have a medical exemption. Then there's also a question about requiring the existing employees to confirm their vaccination status. Yes, again, you can ask for employees whether they have or haven't been vaccinated. That is very clear, you can, particularly if it's something that you're mandating or it's relevant to a public health order and complying with that order. The rules though around keeping that information, so obtaining that vaccination certificate, a little bit more complex in that you have to look about the privacy requirements, so making sure that you're complying with any of the privacy laws. But these are all things that we addressed in the webinar that I sent the link to earlier. So go through and have a look at that. It's on YouTube, and you can also, if you contact me, I can give you the presentation slides for that as well. So we'll wrap things up there. So thank you very much for joining us today. We really appreciate everybody taking the time, and we hope that you've received some information that's going to help you bounce back. But as of course, we're here, we're happy to help. We want to see all of our clients in our network succeed, and we love sharing the information. So thank you, and thank you so much to all of our panelists, Matt, Jess, Nick, and of course, Leanne. We really appreciate you taking the time to be here, Leanne, and giving all of our clients in our network some really valuable information. So hopefully we'll have another one to do soon on another topic, given the changes of the time, and we'll see you again soon. Thanks, everyone.